Today, we're diving into one of the most serious accusations you can make in our justice system. We're talking about a claim that doesn't just question an argument, but the very evidence it's built on. And it all starts with a simple but really profound question.
You know, this question gets right to the heart of our entire legal system, doesn't it? We operate on the belief that the records, the documents, the things presented to a judge are authentic. But what happens when that trust is shattered? What happens when the evidence itself is put on trial? Well, in one particular case, that is exactly what was alleged.
And this whole story really revolves around this one number, 303. That's 303 pages of emails. Think about that. It's a huge binder of evidence, and it forms the absolute core of a truly shocking claim.
Okay, and here's the real kicker. This mountain of evidence wasn't presented during a trial, where lawyers could question it and witnesses could be cross-examined. Nope. According to the court filings, these 303 pages were submitted directly into the record of an appeals court. Now, that is just highly unusual. It's not really how things are supposed to work, and it raises the stakes immediately.
All right, so let's really dig into this unbelievable appellate claim. To understand how serious this is, you really have to look at the details of the core allegation.
So take a look at this timeline, because this is where the claim gets, well, really wild. An employee was terminated in July of 2018, but emails allegedly sent by them were submitted as evidence with dates from months and even over a year later, December 2018 and September 2019. It begs a pretty simple question, right? How could someone possibly send emails from a company account they no longer had access to?
And look, this isn't some vague complaint. The legal filings pinpoint the exact location of this evidence right there in the court record. The 303 pages are right there, spanning from record number R9047 to R9350. Making the claim this specific makes it super concrete. It's not a he said, she said. It's a verifiable allegation you can point to in the official court file.
Now, when you make an accusation like this, that somebody submitted altered or fake evidence, there's a very specific legal term for it. It's called fraud on the court. So what does that actually mean?
To put it simply, this isn't just about one side telling a fib or making a weak argument. No. Fraud on the court is something so serious it's seen as a direct attack on the integrity of the judicial system itself. It's any kind of conduct that literally stops a court from being able to do its job fairly.
And this quote just nails the point perfectly. This exact phrase shows up again and again in the source documents we analyzed. The argument isn't just that the conduct was misleading. The core of the claim is that it actively interfered with the judicial system's ability to impartially adjudicate a matter. That's the incredibly high standard they're arguing was met here.
But wait, there's more. The story doesn't just stop with those 303 pages. According to the filings, that's just the tip of the iceberg. They're presented as the final piece of a much larger, alleged pattern of misconduct.
When you look across 7 different court motions filed between 2021 and 2025, you start to see a picture emerge. The allegations keep piling up, submitting modified documents, producing altered emails, and then it gets even crazier, with claims of creating a non-existent witness, presenting false testimony, and even hiding communications with other people.
And this table here really lays it all out for you, visually. The claim about altered emails first popped up way back in April 2021, and it was still being argued as recently as April 2025. Other really serious claims, like the ones about false testimony, were brought up in later filings. The whole point of showing this timeline is to argue that, hey, this wasn't a one-off mistake, this was a sustained pattern of behavior.
Okay, so we've heard one side of the story, a pretty explosive one. But of course, in any legal fight, there's always another side. So what's the response to all these incredibly severe allegations?
Well, the rebuttal is about as direct and blunt as you can get. In a response filed in June of 2025, the other side just states it flatly. There is no evidence of any forgery or document alteration, period. They deny everything.
And their legal argument really hinges on this. To prove something as serious as fraud on the court, the bar is incredibly high. It's not enough to just suggest something might be wrong. You have to prove it with what's called clear and convincing evidence. So their position is simple. These accusations are totally unsupported and don't come anywhere close to meeting that tough legal standard.
So you have this massive accusation on one side and a total firm denial on the other. So what's the big deal? Why does figuring this out matter so much? Not just for the people involved, but for the rest of us and the entire justice system.
While the stakes are absolutely massive,
If a judge actually finds that fraud on the court was committed, they have some serious power. They can literally strike all of the offending parties' arguments, just wipe them off the record. They can go even further and dismiss their entire case. That's considered the ultimate penalty. Or they can hit them with other sanctions, like making them pay massive fees. And the reason the punishments are so harsh is because this kind of thing is seen as a direct attack on the very idea of justice.
And all of this leaves us with this final, really central question. Our entire system of justice is built on a foundation of evidence. But when that very evidence is accused of being a complete fabrication, it creates a massive problem. How can any court possibly ensure a just outcome when the very tools it uses to find the truth are themselves being questioned?